Hello, everyone. Thank you for joining me today for this MBL webinar on money laundering, the latest guidance for private client practitioners. By way of brief introduction, my name is Tracy Calvert. I'm your presenter. I'm a lawyer, not a practicing one though. Instead, I run a consultancy service which provides regulatory compliance and ethics help for other lawyers and law firms. And the reason why I do this is because for many years I worked at the Law Society as a senior ethics advisor, and then I was employed as a policy executive with the Solicitors Regulation Authority before I left the organisation to set up my own business, Ocals Consultancy Limited, about 10, 11 years ago. The AML topic is one that keeps me very busy. It's essential that every single law firm has considered what laws are relevant to them, how they're going to ensure that these laws aren't broken, and also how they're going to play their part in managing the risks that arise in practice. And every different part of the law firm should be considering the risks that are attracted to their part of the business. And whilst, of course, the conveyancers are always at the forefront of everybody's thinking, actually you're missing a trick if you don't have identified the risks that appear in other departments, such as the private client team. I think it's important to set the scene before we talk about the latest issues for the private client team. So let's start by talking about the Solicitors Regulation Authority, the SRA. Of course, you know that the SRA is the regulator of solicitors of England and Wales, and it also has the power to authorise law firms to provide legal services. And for this topic, the legislation gives the SRA an additional role as a professional body supervisor, a role which requires them to ensure compliance with the money laundering regulations, and a reporting function making reports to the Office of Professional Body Anti-Money Laundering Supervision, OPBAS, on what it's doing, what it's finding, and what the risks are in its particular part of the legal services industry. So the SRA has a very visible role in watching us and ensuring that we comply with our legal obligations. So if you're a partner or you're in a compliance role in your firm, you should already know that the SRA is very active in this area. And a quote on this slide shows the SRA's robustness. This topic and how we deal with money laundering risks is a risk priority to the SRA. And they expect effective management. And of course, our anti-laundering measures are of interest to them because it batters their reputation if we don't do this, and it batters the collective reputation of the profession and law firms. They are constantly undertaking supervisory work, as you'll see from this slide. Their response and our risk management must remain appropriate and active. You'll see, for example, that they are currently focusing supervisory resources on sanctions control, not a topic that they've been concerned about as much in previous years, but now for all the obvious reasons, this is a subject that they must ensure we understand, and it's a subject that I'm going to come back to later on in this webinar. Put it another way, don't be surprised if the SRA makes contact with your firm wanting to know about the AML response. And don't be surprised if they ask questions of individuals within the firm about their understanding of the risks that are attached to this subject. So why should we be bothered? Apart, that is, from the wish not to break the law. Well, there are three regulatory reasons why we need to be bothered, and they're shown on this slide. Firstly, your law firm must remain authorised if it's going to continue to employ you and provide legal services to clients. Authorisation from the SRA gives law firms and everyone in it the right to provide legal services, and it's subject to scrutiny, and in the worst case scenario, a firm can be closed down by the SRA if it fails to comply with authorization conditions. The SRA has a range of disciplinary powers, and it's increasingly using fining powers as a deterrent. Last year, its ability to fine non-ABS firms, non-alternative business structure firms, was strengthened so that it can now fine individuals and firms which are of a more traditional structure up to £25,000 without needing to refer the individual or the firm to the solicitor's disciplinary tribunal. And it's using that increased fining power frequently and very quickly. In January 2023, for example, it fined a law firm £20,000 because the firm was found to have been reckless in failing to comply with AML duties. With individuals within the firm, of course, the SRA has regulatory reach over solicitors, but it also has reach over everyone else employed in the firm because of something called entity-based regulation. Entity-based regulation means that if the firm is authorized, the SRA is entitled to exercise regulatory powers over everybody employed in the firm. Regardless of title, regardless of qualification, there's regulatory reach because of their employment. And I guess a question that you need to be comfortable with is simply this. Are you confident that all your colleagues understand the big deal it is to be employed within an SRA authorized law firm and what the SRA is entitled to ask of them in terms of not only this topic, but also in respect of other regulatory compliance topics? With this backdrop in mind, it's important to establish what you need to know in each individual team. So as a private client practitioner, for example, not only do you need to know how to comply with the money laundering regulations, these regulations increasingly talk to individuals and make them responsible for risk assessment, but also it will be having knowledge about issues peculiar to private client work, getting to know your own particular red flags, and with that knowledge contributing to the firm's collective response to risk management. It's also thinking about other hot topics. I'm going to be discussing all of these during this webinar. Tax advice, being a trust and company service provider. Is that you? And do you know what it means to you in terms of AML compliance? And it's thinking about new developments which are designed to make it harder to be secretive. So the Register of Overseas Entities and the Trust